3, 4.
All right, everybody. It's the first time I did that playing not for my cell phone. Figuring this shit out. I'll tell you what. All right. Cool. Let's see here now. All right. So we're doing some modern American remedies for a procedure for obtaining preliminary relief, reading from a Supreme Court case from 1968. Carroll versus President and Commissioners of Princess Anne. George Fortas, don't remember him or her, delivered the opinion of the court. Petitioners are identified as a white supremacist organization called the National States' Rights Party. They held a public assembly or rally near the courthouse steps of the town of Princess Anne. Oh, that was a town. I thought it was a boat. Sounds like the name of a cruise ship or something. The county seat of Somerset County, Maryland, in the evening of August 6, 1966. Clever. The authorities did not attempt to interfere with their rally. Because of the tense atmosphere which developed as the meeting progressed, about 60 state policemen were brought in, including some from a nearby county. They were held in readiness, but for tactical reasons, only a few were in evidence at the scene of the rally. The petitioners' speeches, amplified by a public address system so they could be heard for several blocks, were aggressively and militantly racist. Their target was primarily Negroes and secondarily Jews. It was sufficient to observe with the court below that the speakers engaged in deliberately derogatory, insulting, and threatening language, scarcely disguising by protestations of peaceful purposes, that the listeners may well have construed their words as both provocation to the Negroes and crowd and enticement to all the whites. The rally continued for something more than an hour, concluding at 8:25 p.m. The crowd listening to the speeches increased from about 50 at the beginning to about 150, of whom 25% were Negroes. The course of the proceedings, it was announced that the rally would be resumed the following night on August 7th. On that day, the respondents, the officials of Prince Anne and Somerset County, applied for and obtained a restraining order from the Circuit Court for Somerset County. The proceedings were ex parte, no notice being given to the petitioners, and so, as far as it appears, no effort was made informally to communicate with them, although this is expressly contemplated under the Maryland procedure. The order restrained petitioners for 10 days from holding rallies or meetings in the county, quote, which will tend to disturb or endanger the citizens of our county, close quote. As a result, the rally scheduled for August 7th was not held. After the trial, which took place 10 days later, an injunction was issued by the Circuit Court on August 30th, in effect extending the restraining order for 10 additional months. The court had before it, in addition to the testimony of witnesses, tape recordings that were made by the police at the night of the August 6th rally. On appeal, the Maryland Court of Appeals affirmed the 10-day order, but reversed the 10-month order on the ground that, quote, the period of time was unreasonable, and it was arbitrary to assume that a clear and present danger of civil disturbance and riot would persist for 10 whole months. We agree with petitioners that the case is not moot. Petitioners have sought to continue their activities, and the decision of the Maryland Court of Appeals continues to play a substantial role in their response to officials. In Southern Pacific Terminal Company versus Interstate Commerce Commission, a 1911 case, this court declined to hold that the case was moot, although the 2-year cease and desist order at issue had expired. It said, quote, the questions involved in the orders of the commissioners are usually continuing, and the consideration ought not to be, as they might be, defeated by some short-term orders capable of repetition yet evading review. These principles are applicable to the present case. The underlying question persists, and is agitated by the continuing activities of the program of petitioners, whether, by what process, and to what extent the authorities of the local governments may restrict petitioners in their rallies and public meetings. This conclusion, that the question is not moot and ought to be adjudicated by this court, is particularly appropriate in view of this court's decision in Walker v. City of Birmingham, 1967 case. In that case, the court held demonstrators who had proceeded with their protest march in the face of the prohibition of an injunctive order against such a march could not defend contempt charges by asserting the unconstitutionality of the injunction. The proper procedure, it was held, was to seek judicial review of the injunction and not to disobey it, no matter how well-founded their doubts might be as to its validity. Petitioners here have pursued the course indicated by Walker, and in view of the continuing validity of petitioner's grievances, we cannot say that the case is moot. We need not decide the thorny problem of whether, on the facts of the case, an injunction against the announced rally can be justified. The 10-day order here must be set aside because of a basic infirmity in the procedure by which it was obtained. It was issued ex parte, without notice to petitioners and without any effort, however informal, to invite or permit their participation at the court proceedings. There is a place in our jurisprudence for ex parte issuance, without notice, of temporary restraint, orders of short duration, but there is no place within the area of basic freedoms guaranteed by the First Amendment for such orders when no showing is made that it is impossible to serve or notify the opposing parties or to give them an opportunity to participate. The court has emphasized that, quote, a system of prior restraint of expression comes to this court bearing a heavy presumption against its constitutional validity from Bantam Books v. Sullivan, a 63 case, and Freedom v. Maryland, a 1965 case. And even where this presumption might otherwise be overcome, the court has insisted upon careful procedural provisions designed to assure the fullest presentation and consideration of the matter which the circumstances permit. Measured against these standards, it is clear that the 10-day restraining order in the present case, issued ex parte without formal or informal notice to the petitioners or any effort to advise them of the proceeding, cannot be sustained. In the present case, the record discloses no reason why petitioners were not notified of the application for injunction. They were apparently present in Prince Anne County. They had held a rally there the night preceding and the application for an issuance of the injunction. They were scheduled to have another rally on the very evening of the day when the injunction was issued, and some of them were actually served with a writ of injunction at 6:10 in the evening. In these circumstances, there is no justification for the ex parte character of the proceedings in the sensitive area of First Amendment rights. A value the judicial proceeding as against self-help by the police is substantially diluted where the process is ex parte because the court does not have here available the foundational instrument for judicial judgment, an adversarial proceeding in which both parties may participate. The facts in any case involving a public demonstration are difficult to ascertain and even more difficult to evaluate. Judgment as to whether the facts justify the use of the drastic power of injunction necessarily turns on subtle and controversial considerations and upon a delicate assessment of the particular situation in light of legal standards which are inescapably imprecise. In the absence of such evidence of the argument offered by both sides and their participation in the formulation of value judgments, there is insufficient assurance of the balanced analysis and careful conclusions which are essential to the area of First Amendment adjudication. At the same time of the fashioning of the order, the same is true, rather, for the fashioning of the order. An order issued in the area of First Amendment rights must be couched in the narrowest terms that will accomplish the pinpointed objective permitted by the constitutional mandate on the essential needs of the public order. In a sensitive field, the order must be tailored as precisely as possible to the exact needs of the case. The participation of both sides is necessary for this purpose. Certainly, the failure to invite participation of the party seeking to exercise First Amendment rights reduces the possibility of a narrowly drawn order and substantially imperils the protection which the amendment seeks to assure. Finally, respondents urge that the failure to give notice and opportunity for hearing should not be considered to invalidate the order because under Maryland procedure, petitioners might have obtained a hearing on not more than 2 days' notice. But this procedural right does not overcome the infirmity in the absence of a showing of justification for the ex parte nature of the proceedings. The issuance of an injunction which abhors a scheduled rally or a public meeting, even if the restraint is of short duration, is a matter of importance and consequence in the view of the First Amendment's imperative. The denial of a basic procedural right in these circumstances is not excused by the availability of a post-issuance procedure which could not possibly serve to rescue the August 7th meeting, but at best could have shortened the period in which the petitioners were prevented from holding a subsequent rally. We need not here decide that it is impossible for circumstances to arise in which the issuance of an ex parte restraining order for a minimum period could be justified, because of the unavailability of the adverse party or their counsel, or perhaps for other reasons. In the present case, it is clear that the failure to give notice, formal or informal, and provide an opportunity for an adversarial proceeding before the holding of the rally was restrained and incompatible with the First Amendment. Reversed. Justice Black concurs in the result. Justice Douglas, while joining with the opinion of the court, adheres to his dissent in Kingsley Books v. Brown, and to his concurring opinion in Freedom v. Maryland. In these opinions, Justice Douglas argues that no temporary restraining order could constitutionally restrain speech, no matter how great any procedural safeguards were. All right, so that's that case. Prince Anne is the county in Maryland where the bunch of Klan members were holding a anti people who aren't white rally. I was hoping it was like a cruise ship or something. Oh well. All right. Our second case today comes again from the Supreme Court of the United States of America. It's a 1974 case called Sampson v. Murray. Let me see, it's not super duper long. It's fairly long. It's longer than Queen Anne was. But not super long. We'll be all right. Have a little drinky drink. Okay. All right. Getting all geared up now. Let's go. The plaintiff in the initial case, who was the respondent in the Supreme Court, because the lower court, the loser, appealed, was a probationary employee of the federal government. She was fired. Her lawyer met with a personnel officer who suggested that reports about her previous employment with a different agency might have contributed to the decision to fire her. If those reports were the reason for her discharge, she was entitled to a more elaborate procedural protections, which had not been provided. She filed this lawsuit seeking a preliminary injunction to prevent her discharge for firing, pending an administrative appeal to the Civil Service Commission. The district judge granted a temporary restraining order forbidding her discharge for 10 days. At that next hearing, he decided that he wanted to hear the testimony of W.H. Saunders, the official who had fired her. The government, which denied that the court had any jurisdiction to inquire into the facts, refused to produce Saunders to the court. The judge extended the TRO, keeping it in effect until the government produced Saunders to testify. The government still refused to produce Saunders and appealed the order prohibiting the firing of the plaintiff. The Court of Appeals affirmed. Murray v. Kunzig, 72 D.C. Circuit Court. Here goes. Justice Rehnquist delivers the opinion of this court. Of course, because our casebook cuts out relevant stuff, we don't have the whole decision, but whatever. We start with Section 3. The district court, exercising its equitable powers, is bound to give serious weight to the obviously disruptive effect which the grant of the temporary relief awarded here was likely to have on the administrative process. When we couple this with consideration of the historical denial of all equitable relief by the federal courts in cases such as White v. Berry, the well-established rule that the government has traditionally been granted the widest latitude to dispatch its own internal affairs, citing Cafeteria Workers v. McElroy, and the traditional unwillingness of the courts of equity to enforce contracts for personal service either at the behest of the employer or of the employee, we think that the Court of Appeals was quite wrong in routinely applying to this case the traditional standards giving more orthodox stays. Although we do not hold that Congress has wholly foreclosed the granting of preliminary injunctive relief in such cases, we do believe that respondent, at the very least, must make a showing of irreparable injury sufficient in kind and degree to override those factors cutting against the general availability of preliminary injunctions in governmental personnel cases. 4. In form, the order entered by the district court now before us is a continuation of the temporary restraining order originally issued by that court. It is clear from the Court of Appeals' opinion that the court so construed it. But since the order finally settled upon by the district court was in no way limited in time, the provisions of Federal Rules of Civil Procedure 65 come into play. The Court of Appeals, whose judgment we are reviewing, has held that a temporary restraining order continued beyond the time permissible under Rule 65 must be treated as a preliminary injunction and must conform to the standards applicable to preliminary injunctions. We believe that this analysis is correct, at least in the type of situation presented here, and comports with good general principles imposing strict limitations on the scope of temporary restraining orders. A district court, if it were able to shield its orders from appellate review by merely designating them as temporary restraining orders rather than as preliminary injunctions, we would have virtually unlimited authority over the parties in an injunctive proceeding. In this case, whether an adversary hearing has been held and the court's basis for issuing the order strongly challenged. Classification of the potentially unlimited order as a temporary restraining order seems particularly unjustified. Therefore, we review the order at issue here as a preliminary injunction. Respondent's unverified complaint alleged that she might be deprived of her income for an indefinite period of time, that spurious and unrebutted charges against her might remain on the record, and that she would suffer the embarrassment of being wrongfully discharged in the presence of her coworkers. The Court of Appeals intimated that either loss of earnings or damage to reputation might afford a basis for a finding of irreparable injury and provide a basis for temporary injunctive relief. This court disagrees. Even under the traditional standards of Virginia Petroleum Jobbers Association v. Federal Power Commission, it seems clear that the temporary loss of income ultimately to be recovered does not usually constitute irreparable injury. In that case, the court held, the key word in this consideration is irreparable. Many injuries, however substantial in terms of money, time, and energy necessarily expended in the absence of a stay, are not enough. The possibility that adequate compensatory or other corrective relief will be available at a latter date in the ordinary course of litigation weighs heavily against a claim of irreparable harm. This premise is fortified by Back Pay Act of USC Section 5596. This act not only affords monetary relief, which will prevent the loss of earnings on a periodic basis from being an irreparable injury in this type of case, but its legislative history suggests that Congress contemplated that it would be usual, if not the exclusive remedy, for a wrongful discharge from federal employment. Respondent's complaint also alleges, as a basis for relief, the humiliation and damage to her reputation which may ensue. As a matter of first impression, it would seem that no significant loss of reputation would be inflicted by procedural irregularities in effectuating the respondent's discharge, and that whatever damage might occur would be fully corrected by an administrative determination requiring the agency to conform to the applicable regulations. Assuming for the purpose of discussion that respondent had made a satisfactory showing of lost income and had supported the claim that her reputation would be damaged as a result of the challenged agency action, we think the showing falls far short of the type of irreparable injury which is necessarily predicate to the issuance of a temporary injunction in this type of case. We therefore reverse the decision of the Court of Appeals, which approved the action of the District Court. Now we have Justice Douglas dissenting. Both the District Court and the Court of Appeals were alert to the necessity to show irreparable injury before an injunction issues. On that issue, there is more than meets the eye. Employability is the greatest asset most people have. Once there is a discharge from a prestigious federal agency, dismissal may be a badge that bars the employee from other federal employment. The shadow of that discharge is cast over the area where private employment may be available, and the harm is not eliminated by the possibility of reinstatement, for in many cases, the ultimate absolution never catches up with the stigma of the accusation. And we cannot denigrate the importance of one's social standing or the status of social stigma as legally recognizable harm. So now we have Justice Marshall and Justice Brennan. So Justice Marshall writes this dissent, and Justice Brennan joins the dissent. In my view, no appealable order has been entered in this case, and both the Court of Appeals and this court accordingly lack the jurisdiction. The orders issued by the District Court are both temporary restraining orders. The first, issued on May 28th, is captioned Temporary Restraining Order, and enjoin Miss Murray's dismissal until the determination of her application for an injunction. The second, issued on June 4th, is also captioned Temporary Restraining Order, and it provides that this temporary restraining order issued by this court at 12 o'clock on May 28, 1971, is continued until the appearance of the aforesaid W.H. Saunders. It is well settled that the grant or denial of a temporary restraining order is not appealable except in extraordinary circumstances, which are not present here, where the denial of the temporary restraining order actually decides the merits of the case or its equivalent to a dismissal of the suit. The court holds, however, that since the temporary restraining order was extended by a district court beyond the time limitation imposed by Federal Rules of Civil Procedure 65B, it became an appealable preliminary injunction. I cannot agree. Federal Rule 52A specifically provides that in granting or refusing interlocutory injunctions on the grounds of this action, The rule applies to preliminary injunctions, and in no findings of fact or conclusions of law have yet been filed in the case, no valid preliminary injunctions was ever issued. Nor would it make any sense for this court to review the district court order in this case as the grant of a preliminary injunction. Where the district court has not entered findings of fact and conclusions of law under 52A, meaningful review is well nigh impossible. It is suggested that if an indefinitely extended temporary restraining order remained unappealable, the district court would have virtually unlimited authority over the parties in an injunctive action. At the outset, this cannot justify this court's reaching the merits of Ms. Murray's claim for a preliminary injunction. Even if the order entered by the district court is appealable, it should be appealable only for the purposes of holding it invalid for failure to comply with Rule 52A. In addition, the government had other courses it could have taken in this case. In view of the district court's error in granting a restraining order of unlimited duration without complying with the requirements for a preliminary injunction, the government could have moved the district court to dissolve its order indefinitely, continuing the temporary restraining order. Had the government followed this course, the district court could have corrected its error and gone on to resolve the issues presented by the application for a preliminary injunction. The end result would have been a grant of a denial of a preliminary injunction with findings of fact and conclusions of law, which we could now meaningfully review. Here instead, we find the Supreme Court determining that although the district court had jurisdiction to grant injunctive relief, the equities of Mrs. Murray's case did not support a preliminary injunction, when neither the district court nor the Court of Appeals had ever confronted the latter issue. Since the majority persists in considering the merits of Ms. Murray's claim for injunctive relief, some additional comment is in order. I agree with the majority's conclusion that Congress did not divest federal courts from their long exercised authority to issue temporary injunctive relief pending the exhaustion of both administrative and judicial review of an employee's claim for wrongful dismissal. I cannot accept, however, the way in which the majority opinion then proceeds to take away with the left hand what it has just given with the right, by precluding injunctive relief in all but so-called extraordinary cases, whatever those might be. At the outset, I see no basis for applying any different standards for granting equitable relief in the context of a discharged probationary employee than the long-recognized principles of equity applied in all other situations. Indeed, it appears that the factors which the majority would have courts weigh before granting injunctive relief are all encompassed within the traditional formulations. The adequacy of back pay as a remedy, for example, is relevant in determining whether the party seeking relief has shown that without such relief, it would be irreparably injured. Likewise, the possible disruptive effect which temporary injunctive relief might have on the office where the respondent was employed, or on the administrative review process itself, relates to whether the issuance of a stay was substantially upon the parties interested in the proceedings. However one articulates the standard for granting temporary injunctive relief, I take it to be all well settled that a prerequisite for such relief is a demonstrated likelihood of irreparable injury for which there is no adequate legal remedy. But I cannot accept the majority's apparent holding buried deep in a footnote that because of the Back Pay Act, a temporary loss in income can never support findings of irreparable injury, no matter how severely it may affect a particular individual. The availability of a back pay award several years after dismissal is scant justice for a government employee who may have long since been evicted from his home and found himself forced to resort to public assistance in order to support his family. And as little solace to those who are so injured as to be told that their plight is normal and routine. Whether common or not, such consequences amount to irreparable injury, which a court of equity has power to prevent. Nor can I agree with the majority's analysis of Ms. Murray's claim of damaged reputation. It is argued that Mrs. Murray can suffer no significant loss of reputation by procedural irregularities in effectuating her discharge because her claim is not that she could not, as a matter of statutory or administrative right, be discharged, but only that she was entitled to additional procedural safeguards in effectuating that discharge. Mrs. Murray does not seek a hearing as an end in itself, but rather to correct what she believes is a mistaken impression the agency had about her conduct in her prior job, in the hope that with the record straight, the agency would not discharge her. She seeks to save her job and to avoid a blot on her employment record that a dismissal entails. Whether the likelihood of irreparable injury to Miss Murray, if she is not allowed to retain her job pending her administrative appeal, when balanced against the government's interest in having her out of the office during this period, supports equitable relief in the present case is a question I will leave to the district court. Because of Mr. Saunders' absence, The district court cut short its hearing on the application for a preliminary injunction before either the government or Mrs. Murray had an opportunity to present witnesses and other evidence. Mrs. Murray still has not had her day in court to present evidence supporting her allegation of irreparable injury, and what that evidence would be were she given the opportunity to, we can only speculate at this point. There you go. That's our preliminary or permanent injunctive relief. And now, for next time, we'll be doing prospective or retrospective relief. Suits against officers and in their official capacities. Cool. All right, sports fans, thank you for joining us. It's been a lovely early morning, late night read. Hopefully you're all up burning the midnight oil with us and having a great evening. Yeah, bumpy ride. All right, folks. Tip your bartenders, tip your waitresses. Last call is in like 4 minutes, so get your drinks in. Love you all, and we'll see you all tomorrow evening for some bar prep stuff and some readings from Conflicts of Law. That's what we have. All right, God bless y'all. Have a good evening.